Hi, good morning. Thanks for having me. I'm excited to be here. So my presentation today is going to be on contracts. I got some tips from the organizers of this event that a lot of you wanted to hear about contracts. So my freebie is not going to be at the end. It's going to be during the presentation. So if you have the capability of taking a screenshot, I'm going to put some contract language on the screen that I think that you should have in your contract to protect you and to protect your animals from liability. Um, so yeah, feel free to take a screenshot. Of course, I'm an attorney, so I have to say that this does not establish an attorney-client relationship. I cannot guarantee any results. These are not magic words, but this is what I typically recommend that my clients put into their contracts. So yeah, plus if I had the ability to have functional magic words, I would probably do something a little less stressful than being an attorney. So anyway, feel free to take screenshots when I put that language up there. Anyway, one of the questions that I got was, what makes a contract legally binding? And the answer is relatively simple. It is offer, acceptance, and consideration. Those are the legal requirements in order to create a legally binding contract. Sometimes this is also defined as intent, meeting of the minds. So an offer is, hi, I have puppies for sale. Would you like to buy a puppy? Acceptance is, yes, I would like to buy a puppy. And then consideration is money. So I will pay X number of dollars to have this puppy, and then you will deliver possession of the puppy to me. So that constitutes offer, acceptance, and consideration. It can also, of course, be the reverse, where someone comes to you and says, do you have puppies for sale? Why, yes, I have puppies for sale. They are X number of dollars. Would you like to buy one? Yes, I would like to buy one. Here's the money. So that thereby makes a legally binding contract. Now, this is an oral example, obviously, but if you put those tenets, those themes into a written document, that is technically, under the law, all you need to form a legally binding contract. That said, that's probably not really what you guys are looking for in terms of like what constitutes a legally binding contract, but that is the legal definition. Anyway, meeting of the minds just means like, does everybody agree that we're all agreeing to do the same thing? Like, does person A and person B, do they understand each other, and are we all on the same page? Because you cannot introduce, if you have a written contract, the court is limited to the four corners of that document. So that means they can only consider what is in the literal pieces of paper that are that constitute your contract. So you can't introduce text messages to say, oh, well, later we decided to do this instead of what's in the contract, and everybody agreed, and I defined a term of this contract in an email, and that's what this means. You can't introduce any of that. So if you want the judge to look at it, if you want the judge to consider it, it has to be in the contract that the other person signs. The other thing to be aware of is that contracts are always interpreted against the drafter. So if you yourself write this contract, or if you have an attorney write the contract for you, and the other person doesn't contribute to the writing of the contract, the drafting of the contract, the legal case law on this is that contracts are interpreted against the drafter. So you want to make sure you have a clause in there that says that everybody agrees to be bound by this, and both sides have contributed to the making of this contract, and both sides agree that they're bound by the terms herein, and that the contract will not be interpreted against one person versus the other. One of the other questions, this is one of the other questions I got: how to find an animal lawyer in your state. There's not many of us. You can always Google. A lot of times if you Google to find an animal lawyer, it will come up with personal injury attorneys who just represent people who were bitten by dogs, allegedly. And so, whoops-a-daisy. And so, you just got to be careful when you're looking at it. They do exist. There's few of them. They don't do it full time like I do typically, but yeah. But you can also contact my office. We are already in 5 states. We can be admitted what's called pro hoc vice. And so that means that we can as long as we have an attorney who's local in your state, let's say you're in Florida. Currently, we're not in Florida, and you want us to represent you in Florida. We can do that. We just have to have somebody who is licensed in Florida, who lives down there, who would be willing to partner with us to help you with your case. Okay, one of the other questions I got was, what language do you want? Like, should we put in a contract? Here's where you can take a screenshot of this. This is where you need to define what constitutes a breach of contract. This particular provision that I have in here does not define a breach of contract because every contract's different, and what constitutes a breach of that contract is also different. So, let's say you're selling a puppy to a purchaser. A breach of a contract for one breeder might look different from another one, but one of the breaches that I'll typically see is that there's a term in the contract that says that you have to let you are agreeing that this puppy or this dog will live as an indoor dog and will receive adequate access to food, water, shelter, and veterinary care. This is very brief for sake of argument. And then when you define what constitutes a breach of contract, you want to specifically spell out violating provision or paragraph 3 of the contract constitutes a breach of this contract. If we find out that your dog is not an indoor dog, that constitutes a breach. So anytime you have something, just make sure that you outline what it is specifically constitutes a breach of the contract, and then what your damages are for that specific breach. Some breeders want money damages. Some breeders want return of the puppy or the dog. So you have to make sure that you spell out, this is the breach and this is what the damages are. Like I said, you can take a picture of this. I would say, just be careful be careful. Whoop, sorry. I don't know what happened there. Wait, I don't know how to go backwards. There we go. Anyway, where it says writ of seizure or writ of replevin down here in the paragraphs, I'm not sure if you guys can see my cursor, but just make sure that you're using the language that's in your state. I don't know the language in every single state. Typically, writ of seizure, writ of replevin is interchangeable through all the states that I work in, but different strokes for different folks, right? I don't know all 50 states. So just make sure you talk to local counsel or just look it up. Google will give you a lot of information as to what the language is. So if you put this in your contract, just make sure you're using language specific to your state. This particular provision basically gives you rights to just go in and take the dog if you want, and that you get immediate possession. You don't have to go through the court process. They're consenting to a final judgment where you get the dog. So this is a very powerful paragraph to have in your contracts. This is primarily, you could use this in in a guardianship contract too. So this doesn't have to be just limited to sale of dogs. This could also be used, and I would especially recommend this for guardianship contracts because I've seen some crazy stuff when it comes to guardianship contracts. Let me pop out of this really quick and make sure I'm okay. As usual, I have running out of time quickly. So let me skip on to liquidated damages. Here's another one you can take a screenshot of. Oops, sorry. Let me get back into mode. So because if you want money damages from either the sale of a dog or you've got some crazy guardianship situation going on, you want to make sure you put in money damages. There's a lot of prohibitions on damages as penalties. So you have to make sure that whatever dollar amount you're putting in here, that it is reasonable. So you don't want to put $1 million or $50,000 or something crazy. You want to put in something reasonable. It depends on what it is because different dogs have different values. You might have, be selling with breeding rights, without breeding rights. They might have a dog that has breeding potential. This might be a champion line of yours, whatever the case may be, but make sure that it's reasonable and supportable, because if you get into damages that are really exorbitant, then the courts will decline to enforce that provision based on the perception that the amount of damages that you're asking for is a penalty rather than liquidated damages. And this is important because liquidated damages are allowed in most states, and they're allowed because in certain circumstances, especially with dogs, it's really hard to know exactly what the value of a dog is, especially when it's just a puppy. And so that's why you have to have this language that because the damages are difficult to ascertain, we're asking for X amount as a reasonable amount of like what we think this dog is worth without knowing. Plus, you always want to throw in there attorney fees, costs, and so that way you make sure you're covered in case you have to enforce any of your contract. Obviously, you want a whole entire paragraph devoted to that because you want to make sure that if somebody does something that violates your contract, that you're not left holding the bag. A lot of people will call me and ask me. So again, you can take a screenshot of this. A lot of people will call me and ask me, well, this person breached my contract. Can I get attorney fees? And I ask them, does your contract allow for that? Well, no, I didn't think I would ever need to sue somebody. Well, then no, you can't get attorney fees. Attorney fees are prohibited. Recovery of attorney fees in America are prohibited under what's called the American rule, which is that everybody pays their own way, right? And so you need to have this in there. Otherwise, you're not going to be allowed to get your attorney fees. So you want to make sure that this is in your contract to protect you and to protect, obviously your investment. And you want to make sure that this is, I have it in here as that the non-defaulting party. So it's like whether you win or you lose, you're the non-defaulting party. So your attorney fees will be recoverable from the defaulting party. But you can change the language in there to make it so that whether you win or lose, like more specifically, whether you win or lose, like if anybody enforces their rights under this contract, your attorney fees and costs are paid. So that way, it kind of prevents the other party from bringing a lawsuit in the first place. You can have arbitration and mediation clauses in there that like force you to go to arbitration or mediation if there's a dispute. I'm not typically, in my experience, I don't find that arbitration is just kind of like court light, like Dr. Pepper light. It's like court light. But so, whatever about that. But mediation, I typically find in these cases, because it's so emotional for both sides, most people aren't willing to mediate. You can go to it, sure, but like they're not willing to actually come to an agreement. I think I'm doing okay on time, actually, for once. So final slide that I want to share with you guys is indemnification. Oops. So this is massively important, right? The buyer shall fully indemnify, hold harmless, and defend. Sorry, I had some language in there. So you can just remove this SVCC in there. But you want to make sure that you have this in there regardless of the type of contract. So whether it is a purchase contract, a guardianship contract, a co-owner agreement, like whatever you have going on, you always want to make sure you have an indemnification. Because let's say somebody does something stupid while they're in possession of a dog that you co-own or that you own outright per the guardianship contract, and the dog bites somebody, and then they're getting sued, and then they find out, oh, well, we've got this co-ownership agreement, we're going to sue this person too because the person in possession of the dog doesn't have homeowners insurance or something, right? You got to think ahead, right? And you got to think worst case scenario. So, if you have a co-ownership agreement, you can make it a provision of your contract that the co-owner has liability insurance or homeowners insurance or renters insurance or whatever the situation may be. Another thing you can make as part of your contract is, if the co-owner or the guardian, like they have to be in compliance with any and all state, county, municipal laws where they live. Because a lot of times I'll get people who are like, my dogs, my mother dog and all her puppies were, I know that mother dog isn't the quote unquote proper term, but I don't like the proper term. Anyway, so like my mother dog and her puppies got seized by local animal control because the guardian didn't get the proper permits that they were supposed to get under the municipal laws. Because sometimes the municipal laws can be really tricky where they say, if you have X number of dogs in your home, you have to get like a breeder's permit. Shoot, I can't think of the word, fancier's permit, or you have to register as a kennel. Like there might be different laws city by city. So, so you got to make sure that whoever has possession of your dogs is applying with their local laws. And like they have and make up, another paragraph that says that I have checked my local laws to see if I need any permits. And I have found that I'm in compliance with it. Because like if your dogs get seized, it's super hard to get them back. It becomes a really big fight, right? Because the government is,